Well, Mark, there was a question about whether or not the towns and the board was authorized to even engage in this lawsuit. Could you speak on that?
Yeah, well, first of all, the board didn't do anything. The board's been sued. The board doesn't need to authorize. I wish the board had to authorize people to sue. It'd be a good world. We could say, you can't sue us. You know, the only thing we've done is in the Litchfield case, we have filed an answer and we said, look, we call what's called a counterclaim, because the towns are saying, please declare this election referendum invalid, and we're saying, okay, based upon the complaint, declare it valid. You know, that's a great act of legal genius on my part. We're just saying the opposite. I mean, we don't have to vote to be sued. Now, the towns, I don't represent the towns. I will let the town's attorneys speak for themselves, so they'll do a fine job. I find the claim that somehow the Litchfield case should be thrown out on the arguments I heard in court to be troubled. I mean, in terms of the validity of those claims. And I'll leave it at that. I put it this way, when I've been in court with the town, the towns have been there presenting your case. I have no idea. And the towns will defend themselves appropriately. Not addressed at the board. Although that'd be a good law if you could say districts cannot be sued unless we vote for let them sue us.
Have you had an opportunity to break out the existing bills and the bill for the month of October?
No. Well, ironically, the way my firm works is probably sitting right now on my desk are the bills for October. I've not been in my office all day. And the one thing I've done in the past, I regret it, when this lawsuit first was filed, you know, our firm would do matters, and, we have bills for certain matters. I just had one matter, everything. I called the referendum challenge matter, and I put for both lawsuits under one entry. That probably was a mistake, so what I'm doing for the month, starting with October, is going to be breaking down, this is the Waterbury case, this is the Litchfield case, because I thought naively back in July that there wouldn't be two cases, that would last this long. I was Pollyannish, I guess. I will go over it. I have to go through the bills, to be honest, and say this was for this case. The one for September, and I guess I have to look through the bills. I would just say, henceforward, since we're done in Litchfield, every cent from this time forward for the Waterbury case.
Personally, I would like to see us have as close to an accurate accounting of the Litchfield case and the Waterbury case.
Yeah.
Because I think people need to understand what those numbers are.
Yeah, first of all, I understand I'm saying this as a lawyer, although not being paid right now at this moment, I usually get paid for my work. And I always viewed it as disrespectful for a client than milk. Because, the thing a client must do is not, I would never ever want to just, do work for the sake of it, somehow to meet some billable target. Which, by the way, I have a 3-year-old son. I've been working too hard at it. I don't need this case, to be blunt. There's been days I haven't seen it, thanks to this case. But the energy spent in the Litchfield case, I have no apology for it. The time spent, I don't apologize for it. That's what I'm supposed to do. Lawyers looking for the truth almost. I have no, and this is a very serious case. I wasn't going to show up in court and just say, hey, how you doing, Judge? Mail it in. I would hope hopefully I prepared enough. But, you got to spend time with that. I have no apology for that. I do feel sick, though, having to go to Waterbury 4 times for, I'm not sure what we accomplished. I feel really sick that for one of the occasions we had to drag witnesses there, and it seemed like a bunch of people were subpoenaed to show up in Waterbury the second time, including banks, or I'm not sure who they were subpoenaed. So, but I appreciate that concern. I think to be honest, the Litchfield case is a valid use of my time. The Waterbury case, every second I spend on it is a second too many.
Okay, I think, first of all, I think one of the questions I came tonight with has been already answered and made clear, and that's, can this can the board simply vote to overthrow the original referendum vote? And the answer is no. The second
Unless
question.
you want to get sued by fault. You know, if you did that, you'd have a different lawsuit. But people voted for it.
There is that potential.
Yeah.
That was made.
Well, representatives might say, wait a second, we voted for this project. You know, this statute says we voted for it, it's passed, what are you doing? So, that's question,
Thank you.
question two.
Well, the other question is more of a statement perhaps and a question. Having personal investment and thanking the region's building committee as well as the region's administration in all the efforts in putting together the building referendum, the outgoing efforts in terms of publicizing it, trying to get as much information as possible to the voting public to make a fair and honest vote. Having that type of personal investment is when the situation arose of the question in terms of notice. I had to take a step back, and I appreciate the question in terms of the concern for the legitimacy of the vote, and also what I'm leading to is the question in terms of the voting public and the risk of going forward with the renovation project, having the bonded amount funded adequately, legitimately, and making sure there's no hiccups in that. And that was considered in as part of your overall perspective of the vote, making sure that part of the legitimacy, making sure we do go forward with the funding. The funding would be, coming from the state, it would be bonded properly, there wouldn't be any hiccups with bonding the project as it stood. And so that's kind of the risk that I saw needs to be sorted out in terms of the Litchfield case. Is that a good statement?
100% perfectly accurate. I mean, I'll just tell you, one of the issues the town raised to us, we had a meeting and went through to address their concerns. They said, look, regardless of their position about the referendum, whether right or wrong, their concern was what happens if we're wrong and we're left holding the bag for $63.8 million. And that's a legitimate question. I mean, the concerns on both sides are legitimate concerns. And that's why we thought the process we chose was the way to solve it. Because if the judge said, this is valid, this is a valid referendum, go forward and act upon it, everyone knows you can go forward and act upon it. If a judge says, no, you can't, you can tell 469 people, sorry, we can't, even though it doesn't seem like a major issue again. To be honest, the legal notice section of the newspaper is on page 62 or 63 or whatever it is, and it's fine print. You question the continued usefulness of it. But we would be able to say to those 469 people, we got to go forward. We got to have another referendum.